Good morning, my dear students. This is Samiullah Khan, selection grade lecturer from Government Giridhar Ram Narayan Institute of Commercial Practice, SJP campus, Bangalore. Yes, in this session, under the chapter Company Secretary, the last session we discussed about the dismissal of the company secretary. Now, before going to the dismissal, this session is meant with an object to acquire the knowledge of company law and secretarial practice. Secondly, to acquire the knowledge and understand the concept of dismissal of company secretary. Now comes to the dismissal of the company secretary. The company secretary is an employee of the company. He may be removed from the office by the board of directors as per the general powers given in the articles of association of the company. He may be removed from his office by following the set procedure. The first one, resolution by the board. A company secretary can be removed by the board of directors by passing a resolution confirming the removal of company secretary in the board of directors meeting. The next one, notice of the removal. A company secretary must be served with a notice of termination of his service in accordance with the terms and conditions of an employment agreement which is taken place between company secretary and the company, that is the board of directors. Next one, filling up the vacancy. If the office of the company secretary is vacated, their resulting vacancy shall be filled by the board of directors at a meeting of the board of directors within a period of 6 months from the date of such vacancy. Yes, these are all the certain procedures that can be followed for the removal of the company secretary. No doubt, the company secretary can be removed by the board of directors. He can be removed by passing a resolution in the board of directors meeting. Second one, notice of the removal. Now the company secretary has to send the notice of the termination of his service. And the last one is the filling up of the vacancy. After the termination, whatever may be the vacancies is resulting, this vacancy can be filled by the board of directors at a meeting within the 6 months from the termination. As this is the procedure for the removal of the company secretary. Then comes to the next one. Now the company secretary may be removed in the following manner. The first one, the circumstances for the removal of the company secretary are as follows. The first one, by giving a written notice. A written notice should be sent to the company secretary stating that he is terminated, he or she is terminated from the post of company secretary. Second one, on the expiry of the tenure of the service. For an example, if a company secretary is appointed for a particular period, say 1 year, 2 years, 3 years, etc. After the expiry of the period, now automatically the company secretary has to be terminated. Next one, as prescribed by articles of association of the company. If the articles of association of a company specifies the manner is in which a company secretary can be removed, then in that situation, now the company secretary got terminated in the same manner as prescribed by the articles of association of the company. The next one, a company secretary can be removed without giving the notice. Now, before this point, I already explained you that a company secretary can be removed by giving a written notice. Without giving a notice, a company secretary cannot be removed. As per the terms and conditions of an agreement, service agreement, which is entered between the company and the board of directors, company secretary and board of directors. But this point number 4 says that a company secretary can be removed without giving any notice. Without giving any notice, a company secretary can be removed, but in a certain situation. Now the situations are, the company secretary can make a lawful profit. A company secretary can make a, now it is a willful misconduct. If he behaves dishonestly, making a secret profits, willful disobedience to the order of the manner, negligence of the duty, insanity, permanent disability or incompetence, insolvency or bankruptcy of a company secretary, during the winding up of the company. Now, in all these situations, a company secretary can be removed without giving any notice. Without serving any notice, a company secretary can be removed. Therefore, we can say that a company secretary can be removed from or terminated from his services without giving the notice in the following situations. The situations are willful misconduct, dishonesty, making of secret profits, willful disobedience to order of the manner, negligence of the duty, permanent disability or incompetence, insanity, insolvency or bankruptcy of a company secretary, and winding up of the company. In all these situations, a company secretary can be removed without giving a notice. Yes, these all are the certain circumstances where the company secretary can be removed. Yes, after this comes to the next concept is the multiple choice questions. Now the following are the multiple choice questions for this session. The first question is, company secretary may be removed from the office by auditors, B. solicitors, C. board of directors, D. None of these. The answer for this question is, it is C, that is the board of directors. The next question. Board of directors have given expressly power in the articles or under general power which the articles generally given them. Now option A, agree. Option B, disagree. What is the answer for this? Yes, it is agree. The next question. Company secretary is removed from the office under the circumstances of, the first one, if he appointed for a fixed period. Option B, if he makes secret profit. Option C, by the court for compulsory winding up of the company. Option D, all of these. What is the answer for this, my dear students? Yes, the answer is option D, all of this. A company secretary is removed from the office in all of these following situation. That is, if the period is expired, if he makes a secret profit, in case of compulsory winding up, now then in all this situation a company secretary can be removed. Comes to the next question, whether this statement is true or false. Secretary may be dismissed for willful misconduct, negligence and permanent disability. Option A, true. Option B, false. Yes, the answer is true. Option A, true. The next question is, company secretary cannot be removed from the office. Option A, if he works for the profit of the organization. Option B, within the tenure appointment time. Option C, both A and B. Option D, none of these. Yes, what is the answer, my dear students? Yes, the answer is C, both A and B. He cannot be removed if he work for the profit of the organization and within the tenure of the appointment time, that is a period. Yes, the next question is, in which manner the company secretary can be removed? Option A, by giving a written notice. Option B, on expiry of the tenure of the service. Option C, manner as prescribed by articles of association of the company. Option D, all of these. What is the answer, my dear students? Yes, the answer is option D, all of these. A company secretary can be removed by giving a written notice after the expiry of a tenure fixed period for which the secretary is appointed, or in any manner as prescribed by the articles of association of the company. Therefore, the option D is the right answer. The next question is, a company secretary can be removed either by giving a notice or without notice. The option is A, agree. Option B is disagree. Yes, the option A, agree, is a right answer for this question. The next question is, a company secretary's service may be terminated without the notice if he makes profit for himself. The option A, true. Option B, false. The answer for this is option A, true. A company secretary service may be terminated without notice if he makes a secret profit for himself. That is why the option A is a true answer. Then comes to the next question. In case of winding up of the company, secretary may be removed without a notice. Agree, option A. Option B, disagree. Now the answer for this is agree. In case of winding up of a company, secretary can be removed without giving a notice. That is the right answer. That is the next one. And the last question, company secretary may be removed without notice for willful misconduct, negligence of the duty, permanent disability, all of these. What is the answer for this? The answer is D, all of these. Now this is the right answer. Yes, my dear students, yes, these are all the certain multiple choice questions or a test questions to know whether you understand the concept. I hope you understand the concept of dismissal of a company secretary. By this chapter, the company secretary comes to an end. We completed the concept of the company secretary. Therefore, after the completion of this session, the outcomes are the students will come to know when the company secretary can be removed from the company. The next one, to analyze and apply the provisions of company law regarding dismissal of the company secretary. Yes, these are all the session outcomes are there. I hope you understand this session. Now we can come with the next session with a new concept. Till that, goodbye. Thank you very much.